In a medical malpractice lawsuit in New York, when I question a doctor during his pretrial question and answer session known as a deposition, is the doctor hooked up to a lie detector to determine whether or not what he's saying is accurate, whether or not what he's saying is a contradiction or a lie? You want to know the answer? Come join me for a walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is no, he's not hooked up to a lie detector, nor is my client hooked up to any lie detector when he or she testifies also during this pretrial deposition process. Now, how cool would it be, though, if the doctor was hooked up to a lie detector when I go ahead and question him? And now he's got to sit and wonder whether his answers are reflecting that he's telling the truth or not telling the truth. I think it would be pretty cool. It would be awesome. However, is that going to happen in New York? The answer is never. Even in criminal cases, which is not what I'm talking about, lie detectors are not reliably used. They are not used. Why? Because they are not reliable indicators about whether or not someone is or is not telling the truth. There are ways to fool a lie detector. There are ways to alter a lie detector's results. And the bottom line is, they are not 100% reliable. So we know that in criminal cases in New York, lie detectors are not used commonly, and in civil cases, they are never used. So no matter how much you believe that the doctor who treated you may have been careless and now is testifying about something that you believe was not true, or there is something that contradicted what he said contained in your medical records. Maybe he forgot that there's a note in there about something that happened. If I catch the doctor in a lie, do I have to go ahead and point it out to him when he tells me it? Do I have to go ahead and say, excuse me, doctor, the medical record says something totally different. Can you explain why your answer is totally different than what it says here in the medical record? You know why that's a terrible idea? You know why, in my opinion, I would never ever do that? I'll tell you why. It's because I don't want to give the doctor an opportunity to explain right then and there. I don't want to give him that chance. If I go ahead and point out that inconsistency, especially if it's a significant component, a significant part of your case, what we lawyers like to call a material, factual issue, in that instance, the moment I give the doctor the opening and point out the inconsistency, he's going to take the opportunity to go ahead and explain away why there is an inconsistency. And I guarantee you, by the time he's done explaining, it's going to sound perfectly normal and perfectly logical. And now, every advantage that I had because the doctor gave me some inconsistent testimony is now gone. And I've lost the opportunity to use it to show at trial that this doctor is being less than truthful. Now, he might simply have forgotten something, right? He could say that. As we get to trial and now we confront him with this inconsistency, the doctor will have to come up with some excuse, some reason why his answer is different, even though the doctor will have had an opportunity to review for accuracy that particular transcript. I guarantee you he's going to come up with some reasonable explanation about why he didn't recognize that there was an inconsistency in a particular answer, and now turn to the jury in a very honest appearing manner and give a long-winded explanation and answer about why he answered the way he did. And you should know something else. Even if I don't give the doctor a chance at trial to go ahead and explain away the inconsistency, but I confront him with that lie, guess what? As soon as I'm done questioning the doctor, his lawyer is going to get up, and now he's going to give his client, the doctor, an opportunity to go ahead and explain. Doctor, Mr. Oginski just asked you a question about this particular answer. Can you tell us, the court and the jury, please, about why it was that you gave that answer? And now he's going to give a long-winded explanation that I don't have the ability to stop him from telling the jury about. However, I will be able to show that the doctor contradicted himself, that even after getting the transcript, he had a chance to review it, and by signing it, he knew that the transcript was accurate and didn't make any changes to that particular answer. Now, what does this have to do with anything? It has to do with the doctor's credibility. That's what it has to do with. And every single trial, no matter what type, whether it's a medical malpractice trial, an accident trial, a wrongful death trial, everything comes down to credibility. The credibility of my client, the credibility of my experts, the credibility of the people my client has sued, whether it's doctors or hospital staff or someone else. It always comes down to credibility. And the jury ultimately will have to determine who is more believable, who is more credible. If I can get the jury to recognize that the doctor is being less than credible on clearly material issues of fact, then now my client stands a much better chance of winning this case than if I had been able to point out the inconsistency to the doctor during the course of his deposition and he gave the explanation at that point. So why do I share this quick information with you? I share it with you just to open your eyes and to help you understand how these types of cases work in the state of New York. You know, I recognize you're watching this video because you likely have questions or concerns about your own matter. If your matter did happen in New York and you are thinking of bringing a lawsuit, but haven't done so and still have questions about whether or not you can bring a case, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.